Welcome to the next edition of Case Law Corner, brought to you by Horlick, Levitt, Di Lella, LLP. I'm Dave Di Lella. If you've been watching any of these, you'll know that what we've created here is a riveting series of case law synopsis to help you be entertained and informed while we're all going through this lockdown. And true to form, I'm in a corner and I'm going to talk about some case law. What are the cases I'm going to talk about today? There's two cases. The first case I'm going to talk about is YRSCC 46 versus Medhurst, Hogg and Associates Limited. It's an old case of the Court of Appeal. And the next case I'm going to talk about is YRSCC 1206 versus 520 Steels Development, Inc. That's a new case from the Court of Appeal of Ontario. They both deal with the same thing, which is Section 23 of the Condominium Act, and that's the notice provision. Why did I choose these particular cases? This notice provision under the legislation, not that exciting, but it's very important. If you are a manager and you're contemplating commencing litigation, you have probably dealt with this, you've probably spoken to your counsel about this. You need to get a notice out there prior to starting an action, because that Medhurst Hogg case that I mentioned from the Court of Appeal has for many, many years stood for the proposition that if you don't get that notice out, your action is a nullity. An action being a nullity may not be that big of a deal, because you may just have to go back to square one, start again. There could be some costs involved in doing that. But there is a caveat to that, and there is a situation where it is very serious, and that is if your limitation period has run. If your limitation period has run, you're out of luck. The defendant doesn't have to pay the piper. Your case will not be advanced, and there may be a negligence case against management. There may be a negligence case against lawyers, against the directors. You don't want to go down that road, okay? That's where this next case comes in. The 520 Steels case went to the Court of Appeal from a summary judgment motion brought by a manager defendant in one of these Section 23 situations where notice hadn't been brought. The underlying motion was a summary judgment motion to have the case dismissed as a nullity. When the case got to the Court of Appeal decided to overrule the Medhurst Hogg case with a 5-member panel. And what they said was interesting. They said, finding that non-compliance with Section 23 results in a nullity would undermine the Condominium Act purposes. Remember, that's consumer protection legislation, and they didn't want to do that. They said third parties should not escape liability because of a failure of the condominium corporation acting on their behalf to notify owners. They said a nullity would be a perverse result, and it really is, because really it's just a procedural defect. So what does this mean? Do you not have to do the Section 23 notice? You do have to do it. You just don't have to panic as much if it's not done. It's now a procedural irregularity. It won't be a nullity. You can start again or keep going. You're not bound by that Medhurst Hogg case, and that's a good thing. So get the Section 23 out. Talk to your counsel about a bunch of other things. Who should be in the action? What level of court it should be in? What's your expert evidence? These type of things. Make sure you're on the right track, okay? But this is good news for the condominium community because we're going to avoid a lot of perverse results, okay? So that's this edition of the Case Law Corner. Hope you enjoyed it. Keep safe, and we'll see you next time.